Philippines has four special laws, in addition to those provided by the revised Penal Code, that punish exploitation of children in its various forms. One of these laws is Republic Act number 9775, an act defining the crime of child pornography, prescribing penalties therefor, and for other purposes. This act is also known as the Anti-Child Pornography Act of 2009. This was signed into law on November 17, 2009. For us to better understand this law, let us define first what is a child under this law. Section 3 of RA 9775 provides that a child refers to a person below 18 years of age or over, but is unable to fully take care of himself or herself from abuse, neglect, cruelty, exploitation, or discrimination because of a physical or mental disability or condition. Second is child pornography. Child pornography refers to any representation, whether visual, audio, or written combination thereof, by electronic, mechanical, digital, optical, magnetic, or any other means of a child engaged or involved in real or simulated explicit sexual activities.
Acts penalized in RA 775 in Section 4, hiring, employing, using, persuading, inducing, or coercing a child to perform in the creation of production of any form of child pornography. Another is producing, directing, manufacturing, or creating, publishing, offering, transmitting, selling, distributing, broadcasting, advertising, promoting, exporting, or promoting child pornography. Possession with intent to sell, distribute, publish, or broadcast, knowingly, willfully, and intentionally provide a venue for the commission of prohibited acts such as dens, private rooms, cubicles, cinemas, houses, or in establishments purporting to be a legitimate business. For film distributors, theaters, and telecommunication companies, distribution of any form. For parent, legal guardian, or person with custody or control of children, knowingly permitting the child to engage, participate, assist in any form of child pornography. Engage in the luring or grooming of child. Grooming is when someone builds a relationship, trust, and emotional connection with a child or young person so they can manipulate, exploit, and abuse them. Children or young people who are groomed can be sexually abused, exploited, or trafficked. Engage in pandering of any form of child pornography. Willfully access any form of child pornography. Conspiracy to commit any of these prohibited acts. Possession of any form of child pornography. The following are explicit sexual activity according to RA number 9775, Section 3. Acts may be actual or simulated. These are number 1, sexual intercourse, 2, bestiality, 3, masturbation, 4, sadistic or masochistic abuse, 5, lascivious exhibition of the genitals, buttocks, breasts, public area, and or anus, or number 6, use of any object or instrument for lascivious acts. In RA 9775, Section 5, syndicated child pornography is committed by 3 or more persons conspiring or confederating with one another. There are many cases of Anti-Child Pornography Act of 2009. One of the many cases is People of the Philippines versus XXX and YYY with GR number 235652, July 9, 2018. In this case, AAA, BBB, and CCC are the minor children of spouses XXX and YYY. AAA claimed that sometime in April 2010, when she was just 13 years old, her mother brought her to a hotel in Makati to meet with a certain John Hubbard, who proceeded to have sexual intercourse with her. AAA further alleged that from 2008 to 2011, XXX ordered her to engage in cyber sex for 3 to 4 times a week in pornographic websites where AAA was shown in her underwear and made to do sexual activities in front of the computer. For their part, BBB and CCC corroborated AAA's statements, both averring that from 2010 to 2011, XXX ordered them to dance naked in front of the computer with internet connectivity while facilitating the webcam sessions and chatting with a certain Sam, their usual client. BBB and CCC alleged that during those sessions, their father, YYY, would be outside the room or fixing the computer. The children all claimed that they were made to do sexual activities to earn money for their household expenses, which were collected by YYY in remittance centers. The RTC and the Court of Appeals convicted the accused parents. The issue now, in this case, is whether they are guilty of the crime charged. The Supreme Court agreed with the ruling of the Regional Trial Court and the Court of Appeals. The prosecution had established beyond reasonable doubt that A. They admittedly are the biological parents of AAA, BBB, and CCC, who were all minors when the crimes against them were committed. B. They made their children perform acts of cybersex for different foreigner customers and thus engaged them in prostitution and pornography. C. They received various amounts of money in exchange for their sexual exploitation of their children. And D. They achieved their criminal design by taking advantage of their children's vulnerability as minors and deceiving them that the money they make from their lewd shows are needed for the family's daily sustenance. Aside from violation of RA number 9208, they were also charged with violations of RA number 7610, or an act providing for stronger deterrence and special protection against child abuse, exploitation, and discrimination, and for other purposes, and RA number 9775, an act defining the crime of child pornography,